Welcome, everyone. Welcome to the Mirantics AI campus. Great to see so many familiar faces and also great to see so many people online. I just quickly wanted to say welcome to the campus. To quickly tell you a bit more about the campus, initiated by Mirantics started in 2021. We built an ecosystem for AI and deep tech companies here in Berlin. We have over 70 companies now here with over 600 members, and yeah, do events like this all the time. So I think today we had 2, on Tuesday we had 4 events with over 250 visitors. So quite active at the moment. And yeah, one of the big topics at the moment is obviously regulation with the AI Act. And we're so glad to have Philipp today here, who's talking specifically about regulating ChatGPT, which is a new topic, but the more important that we have you here today. So thank you so much for coming and enjoy the event.
Thanks so much, Henrik, for the kind introduction, and to everyone from AI Campus, Aranta, Rasmus, and the others, Steve, who invited me kindly to this place. Really great place. I happen to live around the corner, so it's really neat to have this in the neighborhood. Hi to everyone. Thanks for coming out, and I'm sorry it starts a bit late. Actually, I have a good excuse. Deutsche Bahn. What else could it be? It's a topic that is, of course, sort of timely, perhaps even a bit too timely. I'm just back from Brussels, and it turns out that when I talked to people there, they said we can talk about anything, but please don't mention the C word. Okay, so nobody wants to talk about this anymore. But it's really the case that these very days, the European Parliament is struggling to find a position on this, as much you probably know, and it's proving to be tough. It delays the whole schedule of it, and we'll see if in the end they manage to come up with something or not. I'm rather optimistic that they will come up with something. I'm not so optimistic that it's going to be useful. Okay, so we'll see to that. Let's get started right away, because it's of course a complex topic, and we're all super busy, and therefore I just tried, because I didn't have time to prepare for the talk, to just get a little help from our little C-word friend here to design a talk basically, and to write something about it. I hope the video loads, so maybe it doesn't load. It does. Okay, great. So look at what the little bot here proposed. It's actually not too bad. We need to include ethical and moral considerations, privacy and security, IP. Well, this is one topic that's super interesting, and if you want to, we can touch on this in the discussion, but I won't mention it explicitly in the talk here, because otherwise we'll be speaking for 2 hours. But generally, I think this is a pretty acceptable start, and you can guess at the very end how much of the presentation is really generated by friends of these. Of course, I also tried other models like this. I guess most people know Stable Diffusion, which was developed by Björn Ommer, who's a fantastic AI professor from the University of Munich, my own alma mater, as it were. So he's just a humble LMU prof, but just happened to turn out this state-of-the-art model here. And when you prompt it with regulating ChatGPT, this is the funny patterns that you get. So I don't know if that's beautiful, but it certainly shows that there's a lot of potential in this, because if you're a designer and you happen to like this, or you think that people might like this or something else, I mean, you can just start your own designs with this. There's lots of people who are already integrating this in all kinds of tools, and business engineering, business planning, even company founding. If you've been following Ethan Mollick's posts, he's experimenting a lot with this at Wharton, and there's a whole new downrange ecosystem of applications, of course, merging for SMEs, for startups, but also for big companies, based on these models, as most of you probably know. So I want to try to get into this topic and approach it in 5 humble steps. First, trying to look just a little bit into the technical foundations of large AI models. But since we're at the AI campus, I can assume that most of you probably know how a transformer model works, and therefore, we'll only dip into this very briefly. Then we'll turn to model regulation. That is basically the AI Act, the whole theater around it. And I will try to show you that, in my view, regulation is a little off focus at the moment because there's a lot of talk about the AI Act. There's very little talk about the DSA, whilst it should be the other way around. And then from there, I'll try to sketch out some policy proposals and we'll end with some conclusions. All right. This is just an overview, of course, of joint work with good friends and colleagues here, Andreas Engel, I'm teaming up with for a lot of this, and Marco, who's a student actually at Humboldt University, and one of my team members, and Teresa is another student from LMU, not from Björn's team, rather from our team. So, so if you want to know more about this, there's a couple of articles that you can check out. And we also have a recent post out on the Oxford Business Law blog, this short version of our paper. Okay, good. So let's get started. And whenever you have questions, feel free to just, raise your hand or whatever. I can see that there's some in the chat. It's a little difficult for me to navigate thing. But here's a first question by Joanna. Let me take this up. Joanna Bryson, who's of course a person that many of you will know, professor, colleague at ESMT. She writes, do you think releasing a half-finished product was a deliberate regulatory delaying tactic? That's a very good question. I think it was a smart move in terms of trying to just get help from millions of customers in fine-tuning and finishing your model. Have them kind of crowdsource the stuff that otherwise you as the developers would have to do. Basically all of the users are giving all the feedback, doing a lot of work for OpenAI at the moment. And of course, they wanted to get it out first, just to have this first mover advantage. When you talk to people from other companies, they say that, they would have models that are ready, but they're keeping them for good reasons. And there is a whole debate, of course, in computer science about staged release and the right moment to release models in a safe way. So it's, ethically sound, that can be properly audited. But I would not rule out the fact that this, was timed to become kind of a time bomb. Yeah, Julia.
If I may add to that, so sorry. If I may add to that, so I honestly think it's the opposite. So last week I had a call with somebody high rank in the policy team of OpenAI, and they are actually afraid that the European AI Act might even fail because of the problems they are creating, essentially. They're at least a policy person. I don't know if she can speak for Sam Altman, but she said that they are very interested in the European AI Act to succeed and to pass. And I think that's a very good sign, but it doesn't mean the whole sector says that. And of course, she has a certain position within the company, but so she is honestly afraid that this might become too complex and actually make the negotiations fail. That was her impression.
Thanks, Julia. That's Julia Reinhardt, who's a MacArthur Fellow at the campus at the moment. Thanks for that insight. In the end, I believe that I would guess that there was no conscious choice of derailing the AI Act, if anything, and we'll get to this later. Big companies like big tech have an interest in getting this regulated. Long story short, because it just raises the regulatory burden. Of course, they're the ones who could pay for it. If you just raised 13 million from Microsoft, that's easy. If you just raised 13 million from some VC investors, that's difficult. So yeah, but let's get started with some technical things here. So very simply speaking, I want to chart a path from AI to ChatGPT. First question, of course, to the audience: what is AI? Because after all, we got to settle down on a definition if we want to regulate it, or even if we don't want to regulate it. If you want to carve something out, you better know what you're carving out. And you might have seen that the European Parliament, in fact, just last Friday, settled on a definition. And it's tricky. If you have a good definition, please send me an email and we'll publish a breathtaking paper together. Because there is, of course, no uniform definition in computer science. This is I'm using some of the funny art things. This is DALL-E 2 with a heterogeneity style Matisse, in case you didn't recognize it. So a lot of heterogeneity in computer science. Nobody can really say what it is. But broadly speaking, it's of course something that emulates human behavior or human thinking or rational behavior or rational thinking, your pick. If you try to come up with a legal definition, because we have to get one, if there's going to be an AI Act, there must be some kind of definition. We can look at the papers that have been published already, and that's first of all the Council version, which came out in December 6th, was approved. So the Council of the European Union, you might know, is one of the two bodies of the EU which act as legislators. So that's the representation of member states, and they already found their position. Basically what they are saying, this is our view of what the AI Act should be. It's not the final version. It's just their position of one of these two major lawmakers in the EU. And they say, well, AI is something that's a system that's defined by autonomy, and it needs to have an additional or some component of machine learning or of this older knowledge-based approach. Okay, so now let's look, now that's 4 months later, almost to the day, if I didn't miscalculate. This European Parliament, really just past Friday, this was one of the points that has been holding up discussion in the Parliament so much. The definition of AI and rules in ChatGPT, those are the two major points that people are disagreeing about. And now they try to include an international definition from the OECD. And the OECD definition, I think, is stunningly vague and ineffective and misplaced, but it says that basically it's a system that's capable of influencing the environment by producing an output for a given set of objectives. So with varying levels of autonomy. So if you think Excel, Excel, that's capable as makes a prediction. If you have a sum function, have an objective, sum things up, it influences the environment because there's some kind of output and I'm going to do something with it, and it has some, maybe a low level of autonomy. So I guess it's basically any software, unless, of course, you define that you need a certain level of autonomy and you define what autonomy is. So what it boils down to now with these definitions, and I'm pretty sure we're going to have something along these lines in the final version. What it boils down to is knowing what autonomy means. And that's a good question because, of course, people disagree about it, and there's nothing in the AI Act so far that tells us what autonomy should be. I looked this up. Last time I looked this up for real was in 2018 for an article. And for as much as I know, autonomy from a technical level means two things. First is independence from human control. So basically, it could be any machine that just runs without a human having to push a button all the time or supervise it all the time. But that's automation. Okay, that's any kind of very simple machine like your toothbrush, right? Your electric toothbrush is independent of human oversight or technical. Well, it could be. But it needs to be coupled with these learning capabilities. So then again, comes back to machine learning. And I think, well, to the extent that this looks at machine learning more specifically, it makes sense because most of the dangers or risks that we see and associated with AI, like opacity, bias, unforeseeable behavior or predictions, that arises mostly in machine learning environments. Okay, so that's going to be a big point for the trilogue. So for all of those who are not EU law geeks, the thing that happens is that now we have a version from the Council from December, and we're going to have most likely at the end of, say, end of the month or April, we're going to have a version of the European Parliament, and they're going to be very different. And then these two get together with the Commission and start what's called the trilogue. It's not in the treaties, it's nowhere, it's an informal procedure to make sure that at the end, we have one unified text that both of these chambers, let's say, the Council and the Parliament will agree to. And so once we have the parliamentary position, then we have the trilogue, and the trilogue probably, because these positions are so far apart, is going to take all of 2023. My prediction is that we're going to have a final version of the AI Act end of 2023, and then it's 18 months from there until it really kicks in. So you can reckon middle of 2025 for an earliest date of application. Okay, so it gives some leeway, but yeah, Anya. Wait a sec. I think you need to use a microphone because otherwise the people don't hear you.
Thanks. So in the OECD definition, I cannot even see software being a criterion. So this could be a conventional car, like, or is that implied? Is there any software?
It says I left out something. It's like a machine-based system or
Yeah,
something.
exactly. I just read up as machine-based
Exactly,
system.
but they want to check this out as well. So yeah, you're right. I mean, yeah, it comes with the levels of autonomy. I mean, a car that doesn't have electric gears, like let's say 1950s, whatever, Volkswagen Käfer or something like this, would have very low autonomy at least. But it's certainly very broad, and probably broader than anything that people doing AI research would qualify as AI. I think there were more statements. I'm just gonna, yeah, so Joanna says she's never heard about anybody saying learning is a part of autonomy. Well, the Department of Defense in its big autonomy in its big paper from 2016 says so, and a lot of other sources as well. You can look them up in this article of mine, which you find on my website. But it's true that some people don't require learning capabilities as part of autonomy. I would just want to know what else should be. Certainly cannot be only independence from human intervention, because that's automation. Then your electric toothbrush would be AI, which obviously is nonsense. So looking forward to good proposals there. There is a big debate, I should say. Some people, like Joanna just mentioned, she's glad that it's not limited to machine learning. I would be very happy if this was limited to machine learning, but we can hash this out later in the discussion, perhaps. Okay, so let's continue here. So as we said, machine learning is a big part of, it's the most important part, undoubtedly, of our AI at the moment. And then part of machine learning is large generative AI models. And then the question is, why is it large? Does anybody know? Why is it called large? Why is it not? Sorry? Data sets are large? Yeah. Anything else? Sorry? Number of parameters, that's great. And there's something else that needs to be pretty large. And that's something that people often don't think about. And it's the compute. So the compute resources, and that's really the bottleneck at the moment. So the main problem that we have in producing competitive AI, large AI systems in Europe is that we don't have the necessary compute infrastructure. Basically, either you go to a cloud service provider, so you go Amazon, or you go, Microsoft Azure or something like this, or you go to, in Germany, you go to Jülich, which is the Forschungszentrum, and they run all these climate models there, and there's a huge demand for it. So if you're a company, try to do this, good luck. It's really difficult to get a slot there, and that's why there's a big initiative at the moment that is spearheaded by the German AI Association in conjunction with the German Ministry of Economic Affairs, that's trying to build what's called large European AI models, LEAM. And they're trying to put together 300 million euros to build the compute infrastructure. And it's a super interesting project because you might say 300 million, that's quite a bit. But people at the DFP, so German Research Center on AI, they calculated that in the end, 300 million, that's what you need for 50 kilometers of Autobahn. So either you have your new set of Autobahn finishing the A100 finally in Berlin, that'd be fantastic, of course, or you get a new supercomputer architecture. Well, your pick. I have a certain priority there. So the result of this is, of course, that 73% of the reported models come from the US, 15% from China, and that's likely a large understatement because they have a lot in the military. Of course, it's not public, and but technically this leaves then less than 10% for Europe, and that's where geopolitics comes in. If we look at the current situation in this world, is a situation where we want to be dependent on a DeSantis Trump America at some point, or China, or something like this. I think to ask the question is to deny it, right? So this is why this is generating so much interesting thought. Okay, now we're just a snapshot here from what happened after GPT-3 was released. This is just a couple of models here. You can see that, of course, there are models that are much bigger, such as Palm, from Google, 540 billion parameters. Parameters is roughly, it's correlated to the number of neurons in the deep neural network. And but you can also see that there's no single European model in there. There is, apart from Stable Diffusion, which is not on that slide, there is also Aleph Alpha, which is a company that's building large AI models, Luminous, their models called. But other than that, there are probably some somewhere, and maybe in France or so, that I don't know about. But it's just these two that I really know about, and that's preciously little. Okay, now, so that was large. And then, of course, we have the large language models and transformer model. And I'm not going to go into the details so as to not bore you more. It's just a specific architecture that was invented, brilliant architecture that was invented by Google in 2017 to process language more efficiently, much more efficiently. And that's now how we get to GPTs. If your mother asks you, what is GPT? What was that in the end? You can say, well, it's generative because it's generating language. It's a pre-trained thing because it can later be fine-tuned, and it's a transformer. And again, that's this super ingenious architecture that came up in 2017 and basically revolutionized the way we can process language and other sequential data. Okay, and then ChatGPT, of course, is a watered down version of GPT that is focused on conversational settings. Right, so that's how we got to this post and to this prompt. Let me ask if there is any questions concerning the technical stuff. Yes, maybe you want to, before you start speaking, maybe just briefly identify yourself. Cool.
Hi, my name is Thomas. My question is about, like you said, that compute is one of the biggest issues in Europe. What do you think about data collections? Because, for example, Tesla has the Dojo supercomputer, but they also have all these drones out there collecting data. Social media is all in the US and in China. I think it's also because they have this lack of privacy. They can collect all this data.
Yeah.
And in Europe, maybe this is also an issue. What do you think about that?
Yeah, that's right. There's this thing called GDPR that obviously doesn't apply in China and that we don't have in the US. I think it's generally a good thing that we have this and that there are constraints on data collection. Otherwise, the world would be very different in here. But there are ways to say get around this, because I don't want to go into the details. It would be different talk, but there's Article 89 and in the GDPR, there's Article 3 and 4 of the CDSM, the Copyright Digital Single Market Directive. So you have exemptions from data protection and from copyright protection for machine learning purposes, for text and data mining, it's called. So that's an issue as well. That's correct, but perhaps that's an issue for a good reason. I'm less convinced that not having computer infrastructures, we're having this for a good reason. But yeah, thanks. That's another constraint, certainly. Okay, model regulation. So now we get to the AI Act. You might know that it was published in April 2021 by the initial proposal by the Commission, and then came this thing with ChatGPT around, with GPT-3 around, and in May 2022, the French Council Presidency came around with an amendment that was to go down in history, basically, as the amendment that first tried to regulate general purpose AI systems, as they called it. And general purpose AI systems, GPAIS, are defined now, and that's also contested, of course, as systems intended by the provider to perform generally applicable functions, such as image, speech recognition, audio, video generation. Still very broad, but clearly it covers what I call L games, so large generative AI models. And these GPAIS now are the basis of I'll just look at that chat later on, because otherwise I'll derail this too much. Okay, great. Yeah, thanks. Somebody's monitoring the chat, and then you can ask questions. Yeah. Yeah, do you have a question from the chat? From Joanna? Yeah. Wait a sec, where's the mic? Can I hand you the mic? Great.
So Johanna says, I'm glad the EP still doesn't require ML, and I've never heard anyone say learning as a necessary part of autonomy before. I'm really
that we already covered.
We covered that. Okay, sorry. Then as another one, I think autonomy is proactive behavior. So few toothbrushes have it, but anyway, for sure it would be low risk. So it would be no cost if it was included in the AIA. I argued against the ML position here. The US DOD has been talking about that other C word to consciousness. Sorry if I'm taking too much. You can ignore this. This is my question until I get it done. Read Dirk's question. Dirk says, yes, training needs a lot of compute, but inferencing is another point. In my opinion, for example, you can use the German Bloom from the DFKI with 8-bit, and it runs on 2 RTX 3090. So running these models is possible to all of us, and we will be regulated too.
That's right.
That's right.
Yeah, that's a problem because one of the big advances then of the latest version of large AI models, like also Stable Diffusion, is that they were able to compress dimensionality enormously, so that actually you can have Stable Diffusion on your smartphone. I can't find mine, but yeah, you can imagine on your smartphone or in your desktop computer, which of course you cannot with GPT-3, even if you had the possibility to do it. They're only giving you the API, but still too large, if I'm correctly informed, to run it on a normal computer. So that's one thing, one direction into which research at the moment goes, to compress these models to make them small enough to be able to be handled, to be deployed locally, because that's a big factor, of course, economically, competition-wise, because if the model is so large that you can't have it on your company computer, it means that you depend on the API of Microsoft, OpenAI, whoever, Google. If it's small enough to be deployed locally, then you can actually do something with it in your company without having to ask back and forth, negotiate with the company again. So that would be a big step forward, which is why these models are developed by researchers, like Stable Diffusion, like the model, the DFKI model that was mentioned, they're meant to be processed in this way, and there's good economic reason for OpenAI in not doing this. But of course, it's not perhaps what we would wish for. Okay, so now the question is, GPAS or purpose AI system, what's the problem with it? Well, it might be used for any, so the idea is, general purpose, they are general purpose, and therefore, the question becomes, are they going to be high risk or not? Because you might know that in the AI Act, what really matters is not whether you're AI or not. Well, that matters too. If you're not AI, you're not covered clearly. But if you're AI, the question is, are you high risk AI or not? Because if you're not high risk, then it doesn't matter. There's basically almost nothing you have to do. If you're high risk, boom, there's a lot of things you have to care about, right? There's a lot of best practices written into the law, basically, and you have to show and document that you're adhering to these best practices. So then that's the big dividing line, basically, high risk or not high risk. And since GPAS can be used for so many things, the question is, are we going to rubricate it as high risk or not? And the French said, well, if it might be used for some high risk purpose, and high risk, does anybody know what high risk is? What are some high risk areas? Anybody know? Recruitment, employment? Health, medical AI, that's correct. Yeah. What? Education, yeah, that's correct. I thought vacation, yes. That'd be nice. Yeah, critical infrastructure, that's right. Credit scoring, insurance also, judiciary, migration, anything that has to do with administration, basically. For the economy, it's only a few things. It's employment, medical AI, insurance, credit scoring, basically. Okay, so if it might be used for any of these, then the compliance, the high risk system kicks in. Now, the question is, can you give me an example of a general purpose AI system that could not possibly be used for any of these high risk purposes? Obviously, you can because it's a general purpose AI system. So the fact is, by formulating in this way, it just means any GPAS is going to be a high risk system. And this means that any GPAS, and irrespective if it's programmed by some folks at LMU Munich or by Google, it has to perform performance, robustness, cybersecurity testing for all possible purposes. Good luck with that. And comprehensive risk management system needs to be established for all possible high risk purposes with respect to fundamental rights, health, and safety. So again, good luck with this. If you're Google, you just take 2 to 10 million, hand it to somebody, and they take care of it. If you're Björn Noma and you have a chair at LMU, you just stop doing it, I guess. So that's the problem. Or if you're somebody, I can't speak for Björn, but for many small companies, this is going to be a major issue because again, it might be used, of course, for any of this. Yes, Julia.
I don't see why this automatically means that you stop doing it, because that would mean that any pharmaceutical company would not be ready to produce medicine because they have a similar set of things to do. Or like, I know that it's more work, but there are people who want to do more work to create a good business.
Yeah, that's right. Of course, you can try to fulfill it. It raises compliance costs enormously. And I'm not per se against that. I just think it's unnecessary in this domain. We'll see in a second why. And I do think from speaking to some people that this is a major concern because you only have so much money if you're a startup. And I mean, you guys know this better than I do. I don't know. Maybe it's not a problem, but I haven't seen anybody tell me that that's not a problem for them. But maybe I'm just wrong here, and I'd love to, get a view. There's a lot of startup people around here. Does anybody want to say something? I don't know.
Maybe there are some startups that are kind of building solution to actually help other startups to easily build the risk assessment framework.
Yeah, absolutely. This is what we saw in the GDPR space, right? So there's compliance startups, yeah, but still, even if you're trying to build this, I mean, all possible high risk users with respect to fundamental rights and so on and so forth, it just becomes nonsensical because you're covering everything. It's like a book of everything. In my view, there's not much sense to this. And I think it can be done in a smarter way. Anyways, so this is just to put it more extremely, this is funny legal saying from the good old times, which basically translates as if something is impossible, then you're not obliged to do it. I'm not saying it's impossible, but it's it's bordering on very difficult things. And again, this is Dali too, doing Van Gogh painting here. My wife is an art historian, so I'm not so sure if this is really a Van Gogh style, but anyways, it's a smoking computer. Well, yeah, so that brings us to the upshot here. So virtually all L games will qualify as high risk. And that means that they need, for example, comprehensive risk management, which is not a bad thing per se. I'm not saying this. I just think that it's not necessary to do it if only hypothetically there is a possibility that at some point in the future, somebody's going to use this for some kind of high risk purpose. Rather, you should do it if and when it is really used for that very purpose. And I think that's a very sensible way out. Okay. Any questions about this? I'll get to this other point later on to explain more what I mean by this. So there's some questions in the audience. So do you have while we're waiting for the mic, there's a question here. Is there anything comparable in the US to the AI Act? No, there isn't. There are some bills, the Algorithmic Accountability Act, for example, that is stalled in Congress, the Algorithmic Accountability Bill, I believe, in Washington State. But that's very specifically focused on procurement, which is a super important part because procurement, you can imagine, like if a state tries to buy an AI model, there must be something in place to ensure, for example, that that system is transparent enough and that we don't have the problems like with Compass, where the company Northpoint just says, well, it's a proprietary system and you're using it for, predicting recidivism in court, but we're not telling you how it works. You bought it, but we don't tell you. Of course, that's something that must absolutely be avoided. But there's nothing at all comparable to the AI Act, and with dysfunctional Congress right now, you won't see it for the next couple of years. In this framework, well, that's a good point, but that's, for as much as I know, I'm not a super expert in US law in this context, but it's that's only, I think it's only soft law, but it's of course they're developing standards. But as long as you don't have any kind of law that says you must abide by these standards, then it's only voluntary and well, it's voluntary. Yeah, it's a step. Yeah, there's lots of initiatives, but I'm very pessimistic about seeing anything emerging in the US in the near future in terms of national regulation. Yeah.
Hi, my name is Nick. To make it a bit more practical, maybe. So let's say if you are a company that designs T-shirts and on the back end you use DALL-E such that you can type in anything and then you order a T-shirt that is created by DALL-E or something. Why would that then, in this case, be categorized as a high-risk use case, or won't it?
Well, the idea is that DALL-E itself, not the use case, but DALL-E itself, the model itself, would be. Yeah, that's what is in the council amendment that was passed on December 6th. If you can say that, and with image generation, you could perhaps even make a point saying it's not so clear whether this would be used for high risk purposes. Perhaps that's somewhere it's a little trickier. I mean, you can illustrate all kinds of things. But you can certainly build some kind of graphs from them if you want to summarize the table data or something like this. Show proportion of. You want to know how many people from women, men, non-binary are applied. If you want to, you can use almost anything for recruitment, for example. And the idea of this thing of the amendment is to say we regulate the model, not the use case. And my petition would be to say regulate the use case, not the model. Okay, because we're not regulating screws per se, we're regulating screws that are used for X. Like for X in the sense of X, Y, not for. Okay.
Sandra.
Hello, I'm Roberta. Also to make things a bit more concrete, how is the responsibility split between, for example, the Microsoft in this case, or OpenAI, and a company that deploys ChatGPT in a high risk area? Because obviously they cannot be accountable for something that is already completely kosher in the model itself, etc. So how is a company supposed to be responsible for a model built by another company, even if it's just a specific use case that is regulated?
Yeah, that's a very good question. So let's say you're a deployer, you're say a fashion, let's say fashion AI. You're a company and you use ChatGPT to design new funny clothing with great writings on it or whatever, and you sell this, and then there's a problem with it, whatever it may be. And so the idea is, is Microsoft then responsible, or are you responsible, right? Or maybe let's say in a recruitment case, you're a recruitment assessment company, and something goes wrong, and somebody can say, some candidate can say, hey, I was kicked out, but if you had not used this malfunctioning system, but rather looked at it with human eyes, I would have been taken. And so who's responsible? So that's a great question. There are different ways in the law in which you can be responsible. So first off, when you go to a company as a customer or as a candidate in a recruitment setting, you are in a kind of a contractual situation with that company. You actually, at least you want to have a contract with them usually, right? And that gives you certain ways of being able to sue them if something goes really wrong. But in this case, if it's only that the system malperforms, that would probably not be enough. You would, if the system really harms you physically, then yes. If it's just the case that you're down ranked a little bit, you should have been ranked number 2, but you're ranked number 5. That, correct me, other lawyers if I'm wrong, but I would say Loyalitätspflichten, Schutzpflichten, probably not enough. Then, are you a lawyer? Or is that a different question? No, you're not a lawyer. I was going to say, oh, that's interesting. But then the other thing is, even if there is no contractual claim, you can still sue the developers, the manufacturer. But that would be, at the moment, would be OpenAI/Microsoft, not the deployer. That could change if we differentiate more clearly between different parts of the AI value chain. And that is something I think that could make sense for some parts of the AI Act to say that if the deployer is also responsible for some things because we focus on the use case and not on the model per se, then as a consequence, that would mean that the deployer would also be on the hook if something goes wrong, at least externally, if it was something that was the deployer's duty to make sure that this doesn't occur. Mostly, however, if it's something where, if this was badly trained by Microsoft, then generally speaking, the deployer would not be responsible. Or if it was responsible, it could turn around and get the money back from Microsoft. Okay, but it's a complex question because we have another framework that has just been put forward. And I have another paper on this, on AI liability that has, it was on September 28, it was published by the commission, and it's also, it's fairly complicated. But short answer to a very good question.
Thanks.
So basically you mentioned that it is a little less sensible if you do a risk assessment and kind of hypothesize in advance what sort of risk scenarios there may arise. And I was wondering what is logic behind, because what I would sort of argue a little bit in opposite direction, because it would make better sense to actually take some preventive measures and assess risks in advance. And if, for example, it costs you like 50K, and if you have a risk escalated, you may experience reputational damage and legal action against the company or some other damage on the company, which would cost you a little more. So how can you kind of balance that and make sure that you do not end up in a situation and not take any preventive measures?
Well, if it's economically favorable for a company to take preventive measures early on, they're good to go. I mean, voluntarily, you can do anything. It's just a matter of whether the law should, in all cases, oblige you to do that. You could, of course, say, well, the law, there's only an obligation if it's economically efficient, or if you could do some formulas there, but then nobody would know what the law is, right? Because it's impossible to calculate this with enough certainty in all cases. So you have to distinguish between what can be done voluntarily by a company. And I'd say, well, if OpenAI wants to do this, fine, go ahead. If other developers of large generative AI systems want to do a comprehensive risk analysis for all possible scenarios, well, fine, go ahead. Nobody's going to stop you. But the question, should we force everybody to do this? And I think it would make more sense to force them to do this if and when really this is contemplated, and not if it's just a mere possibility. But of course, reasonable people will disagree about that. Some more questions, and then maybe I'll collect these questions and then we'll advance.
Hi, this is Seymour. This might be a dumb question, or maybe I missed it. What's the objective of the AI Act? Like, what are you trying to achieve here? And
that's a great question.
And
nobody knows.
The second part to that, if it actually does become a law, like, what's the implication for a US-based company like OpenAI? Like, they can't operate in Europe, or?
Oh yeah, that's. Let me take this very briefly. Generally, what's the objective? So there's a dual objective. One is protect European citizens from harms, risks of AI. Second is spur innovation. Does it go together? Well, that's precisely a question how to do this in a smart way. It's not a contradiction in terms, I think. You can, and I'm very much in favor of, developing trustworthy, responsible AI that does a good job in protecting, affected persons while spurring innovation precisely in that area. We don't necessarily, I think, need just any kind of AI innovation for the sake of it. But in the end, we want to have, responsible AI innovation. That's what the AI technically should, I think, strive for. And that's also, I guess, what most people would say is the aim. Then your question about US systems, yes, great question. It's the same in almost any area of technology law. Once these systems operate in the in the EU, in the sense of offering services to EU persons in the EU, then that law applies. So companies have a choice. Either they just carve out the EU, they only serve the rest of the world, then they don't have to adhere to EU rules. But if they want to serve a single person in the EU, then they have to abide by the EU rules. And it doesn't matter if they're headquartered in Mozambique or wherever. So that's the idea. And that means that OpenAI, of course, will be covered. And that's what's called, then give rise to what's called the Brussels effect, which means that because there's a lot of purchasing power to be had from the EU, globally companies will adapt to it. Like you might remember that Facebook said they would, withdraw from the EU if it was sanctioned too heavily. Of course, they never did it. Now they're adapting their entire business model because the CJU just gave a big ruling, and also the Irish Data Protection Authority was forced by the European Data Protection Board to rule against Facebook. And that's going to upset their business model to an extreme extent. But they're still adapting to it. They're not withdrawing from the EU. The same, I expect, will be true for AI systems or AI companies. Yeah.
Okay, hi, Julian. So my question is, what are the ramifications of this for open sourcing these models? Because I think if you hold developers accountable or liable even for some, I don't know, the deployment of that model, wouldn't that imply, I don't know, even relicensing or not even open sourcing models in the first place?
So you mean open source developers? Yeah, that's a good question. They are covered too explicitly, particularly in the GPAS definition. It says it doesn't matter if you're open source or not, which is another point where you might be a little critical and say, why don't we try to make it at least a little easier for open source developers? Because if as an open source developer, you have these obligations, plus you have a high risk of liability, because if you violate the AI Act, the upshot will be that there is kind of a presumption against you in liability law. And that combination might make it actually very difficult for open source developers. So I think that we have to find a better solution as well. You could say that, well, I won't go into the details too much. I've written on this a bit. Maybe I'm just saying, this is in the AI liability paper. I have a whole 2 pages or so on open source developers. Okay. There was one other question. I think that maybe you want to have a look at the chat so quickly, and then people don't get left out.
Hi. Well, I have a pretty regulatory, or say academic question. And I hope I haven't missed out on parts of your presentation. You mentioned some of the operative provisions of the AI Act, and we talked about liability. But my question is, what are the regulatory styles as a whole employed in the AI Act? So is it information duties? Is it procedural duties? Is it infrastructure duties? Is it private enforcement? Is it a smart mix of all of them?
Yeah, that's a very good question too. I won't dwell on it too much. Maybe that's for bilateral exchange later on. But basically, it's a lot of top-down regulation, there's not so much co-regulation, and it doesn't have any private enforcement, but the private enforcement comes via the product liability directive. But at the moment, there is no explicit link, or not a sufficient explicit link between the AI Act and product liability directive update. Rather, they wanted to have this in the AI liability directive, which is, they published 2 directives for liability, but the AI liability directive, which would harmonize member state procedural law with evident rules for evidence and presumptions, reversal of burden of proof, that has stalled and will probably never see the light of day. So we're probably just going to have the product liability directive, and that basically will give you a presumption of or a reversal of burden of proof if you violate the AI Act. That's a long, short story. Thanks. Okay, chat.
One question in the chat says here, why can't we forbid usage of AI models in high-risk areas until a proper legislation is designed? That might take a few years, but we can avoid various pitfalls.
Well, that's so-called precautionary principle. That's another principle from regulatory theory. You can try that, but first off, I mean, many of these uses are, there are risks that are bad, but they're not necessarily so bad that you would forego the advantages of using AI, because after all, you take medical AI, medical AI, of course, puts people at risk. But not using medical AI puts a lot of people at risk too. So it's not as simple as saying, hey, let's just forbid the risks. It's a trade-off between different risks. And if you know how, the system, and my sister works in a hospital, she's a doctor. And if you know how they are stretched thin, I'm very much looking forward to any kind of AI help, because it's just going to save a lot of lives. Of course, this needs to be done, in a proper data protection framework and so on. But just saying let's forbid it because there's a risk, I don't think that gets us anywhere. Might in the end kill more people than leaving it, than using it. Plus, of course, if you put it in Europe, then certainly it's going to be developed elsewhere without the trustworthy components that we might want to inspire. And that's not necessarily for the better either. So I think the precautionary principle, it's a fairly outdated principle actually in regulatory theory. And I don't think it's the way forward. Right, exactly. So Julia says, otherwise you would have to forbid the car, but rather you introduce safety belts. Yeah, so if you want to, forbid anything that's risky, well, then you're chilling on your sofa, but in fact, you won't have a sofa because nobody is going to build sofas because it's risky building sofas. So. It doesn't make sense to complain about the yeah, of course, but we do need the safety belts. Yeah, so I'm not saying that. Yeah, of course, but we need smart safety belts. You don't want to spare in front of the there's these economics, calculations, or where you have this spare on your steering wheel, which is a much more effective way of incentivizing non-harmful driving. Because if you brake too hard, you're just killing yourself. But that's another way of doing it, but it hasn't been implemented, because perhaps not the smartest way. And so there's always multiple alternatives, and you want to pick the good one. Okay. So let's see how we can spare this up. Content regulation. Now that's I think that's the spare in large generative AI models. And so I'll try to be quick here. And if you don't speak German, that's an article from Der Spiegel, which is a magazine in Germany that's fairly well known. And I picked up a story from Streitgut, which is a collective of people doing research on AI systems for, the sake of democracy, let's say. And so what they did is they took ChatGPT and had it generate a splendid hate-filled speech shitstorm. And with Copilot, with a ChatGPT functionality for generating code, they also generate the code for maximum proliferation of this shitstorm. Now, they didn't put it online. They sent it back to the developers to say, hey, you've got a problem here. Can you fix this? And OpenAI did react. But this is just to say that that's actually a major game changer, I think. So generally speaking, you can imagine that in our world, with the contested domains that we have in terms of, pandemics, the Ukraine, the aggressive war, the unprovoked attack on Ukraine, and other, areas where there's a lot of social conflict, also with climate change coming up. This is a technology that can actually be used to mass generate fantastically worded, very eloquently written bullshit or worse. And that's, I think, the real problem that we're facing here. Not the fact that, it might downrank one person in a job assessment center. That's bad, but it's not. It's comparably, I think this is the much larger problem. And so what do we have in terms of this and for regulation? Well, we have our Digital Services Act. And if you're not a lawyer, you might still have heard about it because it's a brand new law that was designed to mitigate harmful speech and fake news and all of this stuff. And it applies, again, to preempt that question that was asked before, to everybody who offers services in the EU. So also if, Facebook's obviously a US company, but it applies because they offer services in the EU. And you can use Instagram in the EU, and thus it applies. So what does it mean? What does it do? It has some features that try to make sure that when there is a problem, when there is harmful content out there that a user posts, that the company that is running the system reacts in a fast way to have a look at it and to take it down if necessary. It's called the notice and actions mechanism. It's also well known from copyright law. If you know, so if there's a copyright infringement on YouTube, they have to take it down. Similar thing here. And as you can see, there are some nice things that they added that I think are a good way forward. For example, trusted flaggers, because of course, if you're Facebook, you're inundated with people who complain about anything. It's I don't know. Anything, it could be, I don't know how many complaints they get per day, but a lot, of course, and it's difficult to sift through all of this. Now, that's why trusted flaggers are introduced. Those are organizations that can be registered in a member state and that then actually have a certain status because they've been checked. And if they send in a complaint, then this has to be prioritized because it's supposed to be, from an organization that knows what they're doing, kind of consumer protection organization, think consumer protection organization. And so that gives it's a kind of a decentralized monitoring system because it would be too much for the company itself. So it's decentralized for a little bit. And if you're really big, then you have to actually get, again, here, a compliance and risk management system, but only if you're really big. Okay, so the question is, does this new shiny system, does this apply or problem? And if you're not a lawyer, you have to know that, of course, lawyers always love these different, they don't love them, they use these definitions. And here, it only applies to what's called an intermediary service. And I've put this up here. So basically, the thing that comes closest is a hosting service. Hosting service is anything like Facebook, Insta, any social media network. And because it consists of the storage of information provided by and the request of a recipient of the service. So that's the user, right? So you can host something. That's a hosting service. So it's hosted on that network. So are these LGAMs, large generative AI models, ChatGPT, is that a hosting service? Well, what would you say? Now the answer is basically there. The point is that the information needs to be provided by the user because the DSA, when it was passed, what they had in mind was, your favorite troll on Twitter posting some stuff and, that we don't want to have online. And this has to be taken down. So they said, it has to be provided by the user. Now here, of course, LGAMs, they don't take stuff from the user, only the prompts, but they produce something on their own. So it's pretty clear, and you can look at legislation also, and I've put this in the paper if you're interested. There's some CJU judgments that you can use to this effect, L'Oreal and others if you're interested. To say, well, clearly the DSA does not apply to this. And again, that's kind of funny to think about, right? I mean, it's not so funny, but it's weird. The DSA, which is our prime instrument, has just been passed, and it's already totally outdated. Now people are struggling to, to rein in L games with the help of the AI Act, which is actually the totally wrong instrument. So I believe that there is really regulation out of focus at the moment, and the AI Act, with respect to L games, I think we have a severe risk of overregulation, whilst the real problem, automated hate speech campaigns, that remains unaddressed. And in the area of the DSA, we have under-regulation. And so to give you a final example, what's discussed right now in Parliament, the European Parliament, is an amendment to the AI Act that says L games are high risk for anything they generate, unless somebody looks at this very closely. It's properly reviewed, a human review, and somebody is then legally responsible for it. So the idea is it's not high risk if there's a human standing in for it, and the idea would be like a newspaper, right? You have your article generated, but then somebody reads it, edits it, puts it up, and the newspaper is also then responsible for it. What does this mean? So if I generate a birthday invite for my 5-year-old daughter, which I intend to do in the next months with the help of ChatGPT, and then I'm stressed out as usual and short on time, so I just don't read through all of it, but I just send it out to the fellow kindergarten parents. That's correct. That's a high risk use because there is no proper human review involved. And certainly, boy, I mean, it puts the reputation of my daughter really at risk, and very much comparable, of course, to autonomous vehicles which kill humans. On the other hand, if some funny dictator of a country that's waging war on the eastern side of Europe directs his troll armies to do a really good fake news and hate speech campaign against opposition leaders and roll it out globally. And to make sure that this is well done, the troll army actually checks all of these posts to make sure that there's enough hate in there. Well, and that's not a high risk use because they reviewed it properly, right? So I'm not kidding. That's the way it is regulated right now. Birthday invite for my daughter, high risk. Troll army, looking at it, checking the thing, not high risk. And you get, I don't know. I'm speechless. So state of the art in European regulation. So yeah, we have severe problems here. And if we look again at the geostrategic level, remember this becomes even more important. Okay, so what can we do? Very briefly, I think sensible regulation should be tailored for trustworthy AI. And don't get me wrong, I'm all for, because I was kind of, I'm not anti-regulation, not at all. You can see this from almost everything I write. But so trustworthy AI is super important, of course, and I've written a lot about it. Healthy and competitive AI ecosystem, however, is also super important because if we put up regulatory constraints such that only or de facto only big companies can actually use it, then we will see a further concentration in the market. That's something that was written in the chat as well. And it is something that we already see with the GDPR. It's a nice paper out by Damien Girardin. It's called GDPR Myopia. And they show exactly this phenomenon with respect to the GDPR. Because of course you have a fixed cost of compliance costs, and large companies absorb it much more easily. It's not to say that GDPR is wrong. It's just one thing to consider. And it's also a thing to consider with the AI Act. But the interesting thing is, what's the regulation in the digital economy that takes care of competitive effects? Right, the Digital Markets Act that has already been passed, cannot be amended right now. So I'm saying it's all out of sync. And then finally, environmental sustainability, we probably won't get there at the end because we're running a little shorter in time, but I think that's a really, really important point that is much, much underestimated at the moment, or it's actually at least overlooked. Okay, what can we do? Transparency, mandatory at limited risk management, expand content moderation, and look for sustainability. Very quickly, transparency. Okay, what we can do is we can ask developers and deployers to report on how well the system performs, and also perhaps on harmful content issues that arose during training. We know that OpenAI had all kinds of problems in training. We know that they outsourced the AI monitoring tool to Kenya, but we don't know what exactly they did there. And it would be very helpful to know that. We also want perhaps information on the greenhouse gas emissions footprint. And I think that in some settings, it might also make sense to require end users to actually, disclose that they used games. So of course, in exams, but also when you have newspapers, when you have social media, maybe you want to know about the fact that this was generated in this way. Then, Then comes risk management. Again, I've said this a number of times throughout my talk. I think we should have the high risk obligations, yes, but only if and when it's really deployed in a high risk use case. So the intuition behind this is we have we can buy screws, right? But we don't regulate screws. If these screws are used in space shuttles, then they have to conform to specific standards of screws for space shuttles. And the EU would not be the EU if there wasn't a specific standard for this. And Andy actually found it, and we have it in the paper if you're really interested in it. On the other hand, of course, if you use screws, if you go to the OBI, to your yourself, and you want to buy a pair of screws for, putting together your next IKEA thing, you don't need the space shuttle screws. In fact, if all these screws were regulated to the extent of space shuttles, you'd be paying hundreds of euros only for the screws of your IKEA table, right? So the idea is don't regulate the thing per se, regulate the specific use case. That's what we do in product safety all the time. And that same thinking, the same rationale should apply to large generative AI systems. Okay, content moderation. What can we do? Well, we can try to expand the DSA rules somehow to cover generative AI systems as well, like trusted flaggers, notice and action mechanisms, audits for big companies. Why this? You could say, well, once the trolls, once they put this online on social media, doesn't then the DSA apply? Yes, that's correct. But as we all know, it's often too late then, right? Once the information is out in the world, no way to get this back into Pandora's box. So we want to preempt this from even being generated in the first place, or from, seeing the day of light. And of course, many people will say, hey, that's censorship or free speech, whatever. Yeah, of course, if you want to call it that way, I wouldn't call it censorship. I would just say it's the necessary kind of civilization of discourse that we need in a democracy. We have certain standards. And well, I don't think we need systems spewing out, racist hate speech. But there are people who disagree on that as well, of course, particularly in the US. And a certain person who acquired Twitter also begs to disagree. Well, and then this next frontier, of course, sustainable AI. Well, if you're interested, we can do more on this discussion. There's a lot of research happening on this right now in the computer science community. A lot of awareness is being built because, of course, this consumes a lot of energy, and it has to come from somewhere. Now, in regulation, it had been a blind spot. I must update that slide a little bit because that's also one of the things that is being discussed at Parliament right now. Luckily, so maybe we see some of this in the end, particularly, I guess, in the transparency provisions. I also suggested a sustainability impact assessment. I can tell you more about it in the discussion if you want to. But I think that that's really where we have another really big risk, and that's something we have to address. Where do L games come in? Well, they're super resource intensive, but at the very end, they might even have sustainability advantages because you train the model once, and it's very costly, greenhouse gas emissions wise. But once you've trained it, you can use it for a million purposes. And that's most likely much more efficient in terms of emissions than building 1 million more narrow models. Okay, so that's it. Here are some conclusions. Basically, it's a balancing act. We have to make sure, and that's a prime duty, I think, to maintain the stability of our discourses online. And for this, we need an expansion, I think, of the DSA to L games. We need to also have a look at generating a level playing field so that different companies can compete on fair terms with respect to the generation of L games. That's something that, particularly in Europe, we should be fond of, because otherwise we're going to stick below the 10% all the time in terms of the models being developed in Europe. And but it should be something that is of relevance, of course, for the EU, but also beyond. Should strive for a Brussels effect, but with good and smart regulation. And with that, let me thank you. Thanks also to my team. I've seen Johan, who's here. Thanks so much. Also Andy, who's co-author, and then some of the other people from my team. So this, of course, joint work wouldn't be possible with them without them. So many thanks to you, all of you, and thanks for listening. I have time, yeah.
I wanted to ask you something. I'm not convinced by the screws simile.
Okay.
Because screws, I mean, first of all, you're assuming that these models are necessary, which, I mean, we never talk about it, but maybe, yeah, maybe they are, probably they are, maybe they aren't. We don't know. For now, we know that they might have a lot of downside. We know that they have some upside. The CEO of OpenAI talked about AI memes are going to be hilarious, but I don't know if it's enough. And in addition to this, the models themselves have been built, at least I'm talking about ChatGPT, in a way that is kind of also already ethically questionable, because they have been using materials that were, yes, available around, and you mentioned copyright at the beginning, but then we didn't touch on it. And yeah, and so they are loaded already, ethically loaded, and I don't think that you can just say, yeah, let's just regulate them when we use them for something that might be risky. You said it yourself. I mean, the content moderation, the potential is explosive, etc. So that's something that maybe it's only possible to regulate at the source. I don't know, but yeah.
Absolutely, I couldn't agree more. And I was a bit, it was perhaps a bit short-circuited at the very end, of course, in the conclusion. So I never meant to say that we can't and shouldn't regulate these models. You rightly said, DSA should apply there. I also think, by the way, and it's also in the paper, that non-discrimination law should also apply to the models themselves. But the specific duties that we have in the AI Act, which is basically product safety law, and that's why I think the screw example is correct. That specifically, I think, makes more sense to regulate at the use case level. Now you say, is it necessary to have these models at all? Well, I guess time will tell, but usually the law is not the arbiter in saying, this is what we need, this is what we don't need. Let's just, we'll try it out, and we'll try to, cover the risks and let, the future decide whether it makes sense or not. I can see a lot of advantages. Coming back to the hospital example, my sister and all these persons, they spend so much of their time writing documentation, writing patient letters, stuff that nobody really needs. You only need it in case you're sued, okay? But that means that you cannot really go for patient work. Literally, people are dying, and I know this for a fact. People are dying because of this, because just don't have time for it. And if you work 24 hours straight, and then comes in a tough case, well, every now and then somebody dies. And if you can outsource this, and it has to be done, again, in a data protection safe way, blah, blah, blah. But if you can just have the patient letters written, all the documentation written directly from the files, have this written by a ChatGPT-like program, I think we'd all be a lot better off. So it's one thing, and so it's not about, AI memes or whatever. Yeah, it could be funny or not. But I think, in a lot of cases, this can help. This can help tremendously. Plus, think business. I mean, there's so much that you have to write, that you have to, and that can be automated. A lot of it will be automated. In fact, it is already being automated. If you don't use it now, in 1 year, you're going to be the loser, like literally. Which is why for my students, for example, I've told them to start using AI for their exams. So I'm going to be grading them from March 26 on. I'm going to see how this works. But of course, everybody, they're going to be in the world where everybody's using this. And if in the university they don't get taught how to use it, they're going to be the losers, because everybody else is just much faster, much better. And of course, they need to know the basics as well. So there's going to be some exams without it, but there's going to be some exams with it, I think. So yeah, but again, I'm not against regulating at the source, but where it makes sense, and then we can discuss about what makes sense or not.
I'm aware that my comments are a bit not, timely, in the sense that we live in a society that is made this way, where if a new technology arrives, then everything everyone needs to use it all of a sudden. Otherwise, yeah, you're going to be a loser, etc.
Yeah.
But also it's covering up other social problems. For example, you mentioned the hospitals, and obviously it comes to mind that before looking for the tech fix, maybe we should go back and see if we need to do something about, the personnel there, and if there are some more problems at the core, but that's it. I'm going to stop here.
I'd be the first one to allocate more money there, but good luck trying it. And just, it's not mutually exclusive though, but there is a certain risk it's saying, and I agree. Well, let's fix that through technology, and we're just going to keep the same personnel there. Yeah, that's a problem. That's right. I would fully agree. It's another question over there. And let's have a look at the chat. I don't know. Somebody monitoring the chat? Just don't want to. Yeah, Joanna, I'd be super happy to go for to debate this with you at some point. So it's not via the chat, but in person.
I'm just going to go ahead. Yeah, thank you, Philipp, for the presentation. Super insightful. I have a two-folded question. We were talking about law and regulation in the US as well, and they have a more reactive approach, less proactive as in the EU. First of all, what do you think about that? And the second question is, OpenAI is currently also being sued over the training of their models, DALI and etc. What do you think would be a sensible ruling also from a regulative perspective?
So take the second one first. That's you're right. So this is the Getty case, for example. They actually they sued Stability AI, which is the company that then put forward Stable Diffusion. And so it has a lot of interesting points, and there was some that Roberta also mentioned. Of course, we have to make sure that the training data is used is sourced in a legal way and is somehow curated in a sensible manner, which is why I think that some provisions of the AI Act, and again, that's one of this in the paper, could be applied to the model itself. So, for example, Article 10, which is training data provision, some variety of this, I think, could apply to large generative AI models themselves, irrespective of whether they are used for high-risk use or not. So it's actually, in the end, it's going to be less black and white than, of course, I could do here in 60 minutes or so. The court case, however, that's really interesting. What happens? They are being sued on copyright claims, right? And then we have a problem that, of course, this is US. So first of all, it's class action. And in the US, you have what's called the fair use doctrine. Any specialists for this here? Sort of. Maybe you can say something about it later if you want to. I'm not a specialist on the US rule, but basically there's a way of saying I used it and it didn't really hurt the person, the copyright owner, too much. And there was a good reason for doing this, and therefore I'm allowed to do it. The question is, does it apply here or not? In Europe, it's different. We have, as I said before, we have Article 3 and 4 of the Copyright in the Digital Single Market Directive, which has been transposed in all the member states, in Germany as well. And that basically says you can use it for training as long as it's research, and you can also use it for training for non-research purposes if nobody disagrees, if people don't opt out. And this is supposed to be done in a machine-readable way. The big problem in practice, from what I hear talking to lawyers, is that there is no standard for this machine-readable veto. So basically, if I draw a painting, I put it online, and then for some reason I don't want this to be used for machine learning purposes, so I put a marker there, kind of like a robot.txt file, something, and I just say, hey, this cannot be used. I think some newspaper just did this, right? Washington Post or New York Times as well. Some newspaper just said this cannot be used for machine learning purposes. Their articles, and it's generally not a bad idea, I think, to switch kind of the default. You have to come out specifically if you're against it. But if there is no standard, then trainers, like machine learners, they don't know how to verify that there is no veto. And I know of projects that have died precisely because of this lack of standard. They can't be sure that it's a million things that you scrape from the online world. How are you going to verify this? You can't look through 10 million files to just see if there is somewhere a veto, right? So once we have the standard, then I think that's fairly good system. But since we don't have it at the moment, it doesn't work in practice. In the US, again, it's much more complicated because it's a general rule. If somebody wants to say something about it, I'm more than happy. So I don't want to make any predictions about stability case, the Getty case. That's kind of the problem here. And then, of course, there's the question of, do we have copyright in the stuff that is being generated? If yes, who? But most likely under the EU system, and also under the US system, there's not going to be any copyright of the output in the output, unless you can say that there's a certain person that you can trace this specific output back to in the way that it was generated by the AI. And oftentimes it's not possible because it's in the end, it's really the AI system who's doing it. And it hasn't been designed in such a way that, that actually consciously somebody could say, this is like that person, like that developer really wanted it to be. There's a probability vector in there. A randomness vector. So there's some random function in there, and that makes it even less likely to say, this is just this is a concrete output of a human mind or something. But Andreas Engel would be in a much better position to comment on this. We're actually writing a paper on this, but we haven't finished yet.
And the first question?
Can you remind me again?
What your general thoughts are on being more reactive with legislation?
This is what we've done all the way. Like, for example, liability technically only reacts. Some harm happens, then you sue. There's also a proactive way in the sense that, of course, if you assume rational actors, then they will price this in and, adapt their actions to the effect that, that they anticipate some kind of enforcement. But it's contested to the extent to which this works. So the US doesn't really have a coherent approach there. I am personally very much in favor of a proactive approach in the sense of, it depends on what you mean by proactive.
The AI Act, for instance.
And what is the proactive part there?
To put guardrails and guidelines out already, instead of only having case law decide on what's allowed or not.
Okay, yeah, that takes us very far. Of course, the US, but that's a common misunderstanding, I'd say. The US has a lot of statutory law as well. And it's not the case that in common law, it's only cases that count. And in are you a lawyer? No, okay. Yeah. So it's a common misunderstanding of non-lawyers to say that there's a civil law thing where we have these laws and there's this common law thing where we have only court rulings. In the end, it's actually very similar in both worlds because you have a lot of statutory law in common law countries. And of course, the court decisions matter a lot in civil law countries as well. Once the CJU rules on something, that's the law basically. So I'd be a little, maybe other people would disagree. I mean, private international lawyers, but yeah, totally agrees. Thanks. We have an expert here who totally agrees. That's very good. Thanks.
I just wanted to interject. Yeah, I just wanted to add that, so I've been studying the US a little bit more in the past years, and what I really want everybody to know is that the governing system is, the seat situation in Congress is so difficult. And if you ask the politicians in the Democratic Party about all of this, and there is a lot of dialogue about this, they would subscribe most of it. Actually, when you look at what Senator Amy Klobuchar has been talking about for the last 2 years that we here in the EU have been negotiating the DSA, she wants more or less exactly that. And now the European AI Act, same thing. I have verified a couple of months ago with the American embassy here. I mean, they have to speak for the current government. The current government is very pro, but the majority situation is so difficult that they have to water down more or less everything, not only to please the Republicans, but also those one or two Democrats that they can't convince. And so it's kind of unfair to say that they go a completely different way they would go not the same, definitely not, but a similar, more similar way if they could.
If the Democrats were in control. If Republicans were in control, it would be very different, of course.
Yeah, and so I mean, I've studied I've worked on the GDPR in the US during the Trump administration, and I can tell you, the thing is, it's not about the subject. It's all about different politics around it. Nobody really knows what a real Republican position on a federal privacy law is, because it's actually just manipulated about and talking about other topics. And so that's where the US is on a federal privacy law. There's been a lot of attempts, but the certain Republican politicians just manage to always speak about different things and politicize the whole thing. And that's why actually you see, I just wanted to add that, and I mean, I know this is not about privacy law, but that's why you see a wave, and it's incredible, like a wave of privacy bills in US states, because it's easier to get it through on a state level than on a federal level.
Yeah, California, for example, is very similar to the EU in this respect. But it's only, I mean, it's still California, but it's only California.
It's 40 million people.
Yeah, it's a lot.
It would be in the G7 if it was a country.
Precisely. But still, there's a lot in the rest of the US it doesn't look like. Okay, we have a question there, then we have a question behind you. Right behind you.
Hello, good evening. My name is Salwa, and I'm a founder building a social filmmaking app using generative AI models. So the product is a combination of several models that includes LLM and also stability AI models. And in this case, I think it's very similar to this wave of consumer products that is coming to the market, where it's like combination, sort of Legos of models that is generating unique, novel use cases that cannot be regulated according to like one specific regulation regarding LLM or generative, like stability AI, graphic generative models. So in this situation, how do you think, or what do you predict around the regulation when it's when the direction of the regulation is going towards the models themselves, not the use cases?
Yeah, that's a very good question. If I knew the answer, I'd probably be making a lot of money. It's really almost
to talk afterwards. I
didn't mean it that way. It's just that it's almost impossible to predict what will happen in Parliament and then the trilogue. I think that right now, I think we will have some rule on GPAS, because otherwise it would be the whole AI wouldn't really make sense anymore, and European legislators know that they would kind of ridicule themselves in the eyes of the world if they didn't capture this somehow. But the way in which this pans out is really very difficult to predict. I think there is still some chance for this being regulated on a use case basis, because in the end, people will perhaps understand that this is a more effective and more efficient, because otherwise you're doing all kinds of paperwork, things that might never come to fruition, and might also have this negative impact on AI competition in the market. But as for, then the specific regulation of these use cases is basically these best practices, and that's something that in a lot of cases seems somewhat sensible. Even though we can also discuss the details there. But I guess if I had to make a prediction right now, I can. I think at the moment, most people in the European Parliament still are more on the side of regulating it generally rather than the use case basis. And the council also has this position of general regulations, unless the council switches and some member states, big member states, start saying, this doesn't really make sense. We didn't really think it through. There is still a higher probability of this being regulated at the model level, unless, discourse changes.
Thank you so much. That's very informative. I have another question / a comment about opting out from training. There is a company based here in Berlin called Spawning, I think, and they have helped artists opt out 89 million artworks from the training models. My first thought when I read that is it's a massive set of artworks, and it definitely overlaps with a lot of the artworks that is being included in the training models. And in this case, I'm wondering what is the level of effectiveness when it comes to opting out. I think some artists are arguing in terms of the income they make, or in terms of their sovereignty over their personal artwork. But at the end of the day, when there is such a massive data set, the outcome of models is also gonna overlap with their very own personal work. So I think it's more of a comment rather than a question, but it's also a social issue that we are trying to solve. Do artists consent or not? And when they don't consent, are they gonna still be compensated for their personal work?
Yeah. Yeah, I agree. I think a lot of lower level artists, illustrators are going to be out of work in 2 years. Like seriously, literally, there's no need for it. And they're going to have to look for other things or start cooperating with L games. But then, of course, they can't charge the same prices. Same for translators and so on. It's a lot of jobs that are going to be transformed radically. And about enforcement, yeah, that's. I mean, in the US, you have class action. In Europe, you don't have that, and then that's why they chose to go to the US to challenge Stability AI. And if you have such a large data set, I mean, if they win this case against Stability AI, then that's going to ripple through the industry, right? So yeah, thanks to all of you. This was really exciting. Sorry for going over time a little bit, but I hope it was worth it. And I hope that by the end of the day, you can still talk about ChatGPT without feeling very bad about it. Thank you so much, and thanks to AI Campus University.